Tensions rise in Supreme Court as president of the panel of judges is accused of unfairness in the ongoing election petition hearing.
He's answering the questions the way he thinks he can answer them. So I think that the restrictions of answers by the witness is limiting him in expressing himself. That is keeping his right to answer the questions.
Well, I think that what we are doing is within our authority and we will do it. Sit down.
Tonight we have details of the heated exchange between judge and lawyer on the day when KPMG announced it will audit all pink sheets free of charge.
This is Top Story with Evans Mensah.
Top Story is brought to you by Bond Financial Services, your success, our passion. Belacra Mineral Water, the new generation mineral water. It's also brought to you by Lifebuoy, still 100% better gem protection. Also by Blue Rose Limited, Shelter for All, and Star Life Assurance. There was tension at the Supreme Court today when accusations of unfairness were thrown at the president of the panel of judges hearing the election petition. Lawyer for the petitioners did not mince words. He accused Justice William Atuguba of curbing the rights of his clients to answer questions posed by NDC lawyer Chachi Chikata. Philip Addison was unhappy with Justice Atuguba's interjections in the course of Dr. Bawumia's answers. The controversy started when Mr. Chikata posed a question on the public declaration of victory made by MPP General Secretary Kojo Usefriye on December 7. Listen.
I'm saying that you made public declarations that you had won from the results that you had.
The only person that declares a result ultimately is the Electoral Commissioner. And I'm not aware that we can declare the result. We can also express our feeling maybe that we...
Just necessarily off tangent. The question is whether your people declared...
My Lord, we are being subjected to a number of irrelevant questions. And when the irrelevant questions are asked and the witness is giving the answers, he's being stopped in giving the answer. Whereas the questioner is not stopped in these irrelevant questions that are being asked. Well, and I think it is unfair that if he asks those questions, the witness should be allowed to give a full answer to those irrelevant questions.
Oh, now you have to take care about what your view is about relevancy. We are following the case, and relevancy depends on us.
I've objected to all these line of questions.
Will you resume your seat? Listen to me. The questions about declaration of victory and all that, if you feel they are irrelevant, as far as I'm concerned, they are vitally relevant to this case. And the answer he has to give should be pertinent. I think we have, you see, we have authority. We don't want to exercise it too much, but we cannot be overrun too. All right. Yes?
Yes, I think many party officials may have made statements relating to a victory, but I am saying that the only person able to declare is, I'm not aware of the specific statement also Afriye is supposed to have made, but if party officials make statements, that is their view. We only examine the record.
Oh, look. You are a doctor, you are very intelligent and all that. You see, help us. You see, look, this case, let me tell you, people are approaching it from two fronts. The political front and then the issues here. We are dealing with only the issues here. So bring your mind to the courtroom. Let us get at the facts of the matter and ascertain the truth and declare it.
Now, Mr. Addison rose a second time to challenge the judge when Dr. Bawumia's questions became a subject of another interjection. This time, Justice Atuguba used his authority and stopped him.
Very difficult for the witness to answer questions the way your lordship has problem with every answer that the witness gives. I see that it's going to be very difficult for him to answer the questions.
Because it has come to a stage when we think we have to, control these things.
The questions that he's asked, he's answering them according to the way he understands the question. But he's always limited in his answers.
what our party has decided is not. I mean,
he's not a lawyer. He's a layman. He's answering the questions the way he thinks he can answer them.
So
he has the restrictions on answers by the witness is limiting him in expressing himself. That is keeping his right to answer the questions.
Well, I think that what we are doing is within our authority, and we will do it. Sit down.
I am joined on the line right now by a member of the NPP legal team, Madam Gloria Kofu. Also joining me on the line live now is a member of the NDC legal team, Ibrahim Amali. But thank you very much, lady and gentlemen. I want to start with you, Madam Kofu. I know you were unhappy with the interjections coming from the bench, but did you appreciate Justice Atugube's apparent frustration?
Excuse me?
I was wondering if, clearly from what you've just heard, your lawyers were unhappy with the interjections coming from the bench. But did you appreciate Justice Atugube's apparent frustration with the answers that he was getting?
Well, our position is that where Mr. Chikata has persisted in asking what we consider repetitive questions, if he's allowed to ask such repetitive questions, then by parity, the witness must also have a right to respond. You will notice that Mr. Chikata, even where the court has ruled on the matter, instead of accepting this and going on, would engage the court in arguing forwards and backwards all through the court. And sometimes he got a concession out of it. Now we have a witness who is trying to answer questions within the context of the evidence that is before the court. But Mr. Chikata will insist on getting what appears to be a response that he is expecting. Then Justice Atuguba thinks that he is being too long. A number of times he said that, as far as he was concerned, the answer to a particular question was contained only in the last sentence that he gave, and that all the others were, as it were, not necessary. That he was engaging in political commentary. Indeed, he also said that the case was being fought on two fronts, the political front and then in the court, and that Dr. Baumia should bring his mind to bear on what is being done in court. But we felt that Dr. Baumia was doing the right thing because in this particular instance, Mr. Chikata insisted on asking questions about these 22 locations where we say that they were outside of the over 26,000 polling stations that have been listed by the Electoral Commission. We originally started with 28. We went through and we realized that we did not have evidence to support the 28. We limited it to 23. By some printing error, the 23rd one did not appear in what we served on the party. Later on, we discovered that when we had previously indicated 22. But the court said that because Mr. Addison from the bar had considered 22 polling stations of places that were not listed in the 26,000, we were bound by it. We accepted it. And yet, Mr. Chikata kept going back to that issue. And then when Dr. Baumia wants to answer and relate it to the further and better particulars and his analysis, Mr. Chikata would prefer that he does not do it that way, but must answer give a simple yes or no answer. And that has been the reason why all these have arisen.
Clarify this for me, though. The president of the panel today, on more than one occasion, expressed in his view what he thought was his displeasure with some of the answers given by your client, forcing him to interject at least a couple of times. How normal is that in a trial of this magnitude?
Oh, in essence, a court is supposed to enforce the principle of natural justice. That is that all parties be heard. So the opportunity by any court, the court has to afford all the parties opportunity to air their case, to establish their cases. However, there are rules that pertain to it. The court essentially constitutes what we will call a referee. That is like a football game. You want the rules to be adhered to. So it is normal for a court to interject in order to control the proceedings. You will recall that there had also been times when Mr. Chikata has been advised, especially today, on a number of occasions, that the questions that he was asking the witness were in the nature of addressing the court or that were trying to elicit responses. That should be what the court should be doing in its judgment. So yes, it is normal for the court to come in. It considers it necessary.
I've also just been joined right now by Mr. Maliba, as I announced earlier. He's a member of the NDC legal team. Mr. Maliba, you were in court today. First, give me the clarity on this. Is Mr. Chikata done with his cross-examination?
Not yet. He has given indications that he will continue tomorrow if they are able to submit the list that was given to them to provide counterpart serial numbers. And so if he's done with that, he will await the audit report coming from KPMG, and he would have to cross-examine after that audit report. So he's not done completely yet.
I'm sure you've heard severally the accusation of repeated questions. Actually, today, one of the judges had to make the point of time wasting, all directed at your own lawyer, Chachi Chikata. Do you accept those criticisms?
You must put this in context. You have an evasive witness in the person of Dr. Bawumia who will not answer questions directly, very simple questions. He would not answer them. He will not admit the truth of very simple questions. And so if you have such a witness, you have no option but to try to test the consistency of his questions. And so you find Mr. Chikata trying to always repeat a question so that it will match or otherwise with an earlier question that was not answered properly. And so it is the nature of the witness we have. Very simple questions which need just yes or no. He goes on. You made a point that Justice Atugba told him that this is not a political platform. Or I would also add that that wasn't a lecture room. But he will go on and on. The answer will be missing in his analysis. Then it will now take the judges to try to decipher what was his answer. So because of the nature of that witness, there's a need to do what Chikata was doing.
Madam Gloria Kufuor, he raises questions about the conduct of your witness. He calls him evasive.
I'm very worried about the gentleman going on the way he is. I am worried because the performance of a witness, his credibility, the reliability of his evidence, his demeanor, all that is within the preserve of the court. So to come on a platform such as this and call him evasive witness, it's clearly unethical, it is against the rules, and he ought not to be making such pronouncements. If indeed he is being evasive, if he's not being truthful, it is not for him to come and say it on air. I can only say that it is improper, and it is not for anybody to prejudge what the court's decision should be.
Mr. Maliba, you acknowledge that?
What I have said is that he tried to link up his evidence with the questions that require that he links them to the further and better particulars, which Mr. Chikata does not want.
I see. Mr. Maliba, quickly on that. You acknowledge the point she made right now about the unethical nature of what you said.
I agree with her. The point is that you could have an evasive witness, you can even have a hostile witness, and if you describe the witness as such, it has nothing to do with you discrediting that witness. If you are not answering questions directly, you can be described as an evasive witness. It isn't for the court alone to describe him as such. We, in our camp, see him as such. And so there's nothing wrong with describing somebody as a hostile witness or describing somebody as an evasive witness. There's nothing wrong with that.
My final clarity, just want to seek, Madam Gloria Kufuor, just before the court indeed today adjourned to tomorrow, there was a bit of a direction from the court that something needs to be done, and for which reason they are adjourning, not because Mr. Chikata didn't want to continue with his cross-examination. What was it exactly the judges were referring to?
Well, to start with, Mr. Chikata expressly said he could not. You know, Dr. Bawumia made a correction of his testimony yesterday under cross-examination to the court. Mr. Chikata then indicated that if he brought that in, then he would be inclined to continuing with his cross-examination. And the court here said, yes, we have not reason. If you intend to continue, we are available to hear you. Ultimately, he said he was not prepared to go on with his cross-examination until tomorrow. But quite interestingly, the court indicated that the matter was being adjourned not because somebody said he could not go on. What is outstanding really is that you will recall that Mr. Chikata was cross-examining Dr. Bawumia over the duplicate serial numbers and wanted him to find counterparts of the serial numbers in other categories. That was taking a bit of time, so the list was submitted for that to be done. The following day, which was yesterday, we took those things, but we lifted them from our database in an order that did not conform with the way it was listed by Mr. Chikata. He said that he would prefer that the format of our responses is based on what he has submitted.
Madam Kuvo, sorry to interject, but I just ran out of time. Just quickly, so that's what he was correcting today.
We did a part of it because it is time consuming. It takes time to list these things and rearrange them in the format that he has submitted them. So we have given them part. We are working around the clock, and we are hopeful that by tomorrow, even if we are not able to do all of them, we will submit the rest to them. But he also said that he has ended cross-examinations subject only to these documents which he indicated will not take a long time, provided he has all of them, and also when the results of the audit being carried out by KPMG is concluded.
Thank you very much, Madam, for your time here on Top Story. And she mentioned KPMG also at the Supreme Court today, where members of the accounting firm KPMG tasked with the responsibility to audit all pink sheets tendered in evidence by the petitioners. They announced they will carry out the audit, estimated to cost 100,000 cedis for free. That's it for Top Story. My name is Evan Spencer. Join me on Newsnight as we explore the other key news items making the rounds today, particularly in Kumasi. We're told there's been a debate today addressed by the Asante, and we'll be telling you what that is all about.